The Supreme Court heard oral arguments today and will again tomorrow on two cases that could restructure everything we know for both online speech and content moderation. The two cases, one involving Google and one Twitter, stem from disputes over ISIS recruitment materials on big tech platforms. Now, at stake in both cases is the liability protections tech providers have for content that they host and distribute. Now, joining me now to discuss this and other cases that the court will be reviewing this term is Ken Klukowski, former senior counsel in the Civil Rights Division of the U.S. Department of Justice and former special counsel in the White House Office of Management and Budget. He has also litigated constitutional cases in the Supreme Court. Ken, welcome back to Washington Watch.
Tony, it's great to be with you. Thanks for having me.
So let's start off, just provide an overview of the two big tech cases in front of the Supreme Court this week and what that could mean for this Section 230 and practical application for users.
Well, that's right. Today, and these cases are tied together. There are some lawyers who are involved in both cases. And it looks like if there are real fireworks, I'm actually expecting them tomorrow just because of the superstar lineup of lawyers who will be arguing tomorrow. But today, in the case Gonzalez versus Google, you had a 23-year-old woman who was murdered. And her family had sued, saying that her murderers were inspired by ISIS videos, that they were radicalized by these ISIS videos that were carried on YouTube, and that YouTube is owned and controlled by Google. And but the argument got a little muddled. A number of the justices were mentioning that kind of the argument that the lawyer for that side was presenting to the justices seemed to be different than what they had actually filed their legal briefs on. So it's like some of the justices, I think, were signaling that their questions were keyed to an argument that was now not being presented to them, basically with one being, we think that if you have content there and you don't have mechanisms in place to screen it, to block it, to take it down, that content that's left there like that, you can be sued for. But then the other argument that was presented seemed to be, no, we're not saying you need to take it down. We're just saying you can't be promoting it. You can't be endorsing it. And so there was a real question on what yard line the football was on. And the justices, a number of the justices seemed to really struggle with where exactly you draw that line. Justice Elena Kagan made a reference at one point that the sort of things that were being asked for here, she thought sounded like the kind of thing that Congress could address through legislation, but that it was hard, that courts are not to engage in writing bills. So that the kind of reasoning and rules you might need might be more appropriate for legislation rather than court action, which is just supposed to interpret the language that's already in the law. And so I'm not quite sure where things are going there. There was a lawyer from Google who did a good job defending their position. Then there was a deputy solicitor general from the Justice Department who was given the position of the United States government, who were asking for something very different. In their case, they just said that in this case, the U.S. Court of Appeals for the Ninth Circuit, they said took this content neutral approach of identifying these tools and putting together this toolbox.
Right.
And DOJ is saying, we think this toolbox is wrong. And so the case should just be thrown out and sent back to the lower court, with the Supreme Court just explaining what the analysis should be going forward. So it was kind of muddled today.
Yeah,
really
I listened to part of it, and it got a little technical, talking about the use of algorithms, and that seemed to be a major portion of the discussion today. This deals with them, summarizing it essentially deals with them allowing ISIS content on there that may have led to violent actions by those recruited by ISIS, correct?
That's right, yes.
So what implications would that have? Because Congress has been looking at this same section, because it appears that these social media platforms, they don't want to choke down ISIS. They want them to have access to the platform. But conservatives, they seem to be restricting conservative content.
Well, and there were comments about that today. I mean, it wasn't, explicitly tied on ISIS on one side, conservatives on the other, but there were comments there about bias on one side. Who would actually make these decisions? And it kind of it wasn't thoroughly discussed, but I think the inference was there for a lot of people that it's a matter of saying that the gatekeepers here are not neutral. They have their own agenda. Surely they don't want people getting killed. So I
Right.
mean, certainly no one
Well,
was suggesting there were
could
any
could
ISIS
there be
sympathizers.
could there be any outcome here that would end up being favorable to conservative speech?
I'm reserving judgment until we get past the argument for Twitter yesterday, and there was even some back and forth on that today. Like I believe it was Justice Barrett who made the point to say, "Well, wait a second. If I am just retweeting, so now moving off of Google and YouTube and actually using an explicit example from Twitter, where she said, if I just retweet something, uh, is that content on my part?" Or do I need to make a comment? Like if it's a video of one person killing another person, do I need to make a comment or an article on it? Do I need to make the comment to say this video proves that so and so is the killer? Do I need to say those words when I retweet it to be for something to be actionable against me? Or is even the act of retweeting it just using the system, does that open me up to it? So I would say, Tony, that many of the questions that were asked seem to be poking holes at the wording of Section 230 of the Communications
Well, and
Decency
that's
Act,
that's been kind
CDA.
of a veil for social media to hide behind. But
Yes,
if I mean, you
yes.
could, I guess, if it is pierced enough, you could have conservatives taking legal action against them for restricting their speech. Could you not?
You could, and there is some litigation underway that cases that have no bearing on today's lawsuit. Conservatives taking very, very different actions. One case ongoing right now is making the point to say that if a social media platform is working in conjunction with the government, taking its marching orders from the government, promoting the message the government says they want promoted, and silencing dissenting voices that the government doesn't like, and is doing so both with the shield of this Section 230 shield that we've discussed, that being a special benefit they enjoy, but also with public statements saying, if you don't clean up your house, we're going to change the law to punish you. So that when the government is both using a carrot and stick, and you're carrying a message the government approves of, you're stopping a message it doesn't. There are arguments out there in court to say that that private corporation has now become just an extension of the government, almost like a
Well,
contractor, and as such should be subject then
to the
to the
First
First Amendment
Amendment,
in
right?
terms of not being able to
Yeah,
discriminate against viewpoints the government doesn't like.
yeah. We've had Louisiana Attorney General Jeff Landry, who has some of those suits against the federal
Yes.
government. So I want to move to a different topic. The Supreme Court will hear arguments next week in two cases dealing with the president's student loan bailout. Is that move by the president at risk, you think, in these cases?
Well, if we reach the legal merits, I would say that most certainly it should be struck down as an illegal act, that only Congress can decide to spend money, and that when you are paying off $500 billion in student debt by transferring it to taxpayers, you are both incurring debt for the federal government there, and you are spending money as the federal government. And those are two things that the Constitution says only Congress can decide. Every time we have a fight over the debt ceiling, the debt limit increase, that's a reminder that only Congress can decide when the executive branch can borrow money. And of course, we all know that if Congress doesn't fund something, it doesn't happen. So only Congress can spend the money. So the President Biden's action there, I think, was blatantly illegal. But the question is whether the petitioners, well, the plaintiffs, because they were actually winning in some of the lower courts, whether the challengers to this program actually have the legal standing to actually bring the ones to bring this lawsuit. So I'm not sure that it's going to. There are real challenges in the briefs at the Supreme Court as to whether these states and these private actors, whether they're being injured and can be claiming an injury here that is sufficient for Article 3 of the U.S. Constitution to give them the power to have been the plaintiffs in the trial court on this. And if not, then the whole case is thrown out. But whether they reach the merits in this case or in a future case, I think there are or entities that do have standing, but we'll see if the court thinks these are two of them.
Well, just very quickly, what if these individuals, and we've got states here that are acting, bringing these suits, who would have standing if they don't?
Well, I think the U.S. Congress has standing. I think that the U.S. House could, by majority resolution, could authorize a member of the House to bring suit in the name of the House. That this was a violation of the Constitution's appropriations clause, which says that no money shall be spent unless it's been appropriated by Congress. Congress never appropriated this. So I think Congress could sue.
Okay.
Specifically the U.S. House. Obviously, the Senate under Chuck Schumer won't do it, but I believe that the Republican majority in the U.S. House, they could, by majority action in the House, pass a resolution authorizing a member to bring suit on behalf of the House.
And they've done that before.
The U.S. House would have standing.
And they've done that before.
That's right. And yes, they have. It's called legislative standing doctrine.
Right.
The big Supreme Court case that lays out the contours is called Raines v. Byrd, 1997. I believe under these circumstances, the U.S. House would have standing to sue, and I believe they'd win.
Oh, I may have a couple conversations there then. Before we run out of time here, any other cases that we should be looking at in this term of the court?
Well, I mean, there's a number of them going on. I mean, of course, 303 Creative, the whole issue about public accommodation laws versus the First Amendment rights of a web designer in terms of if she has a religious objection to developing content to celebrate a same-sex marriage. That is certainly there. Next month, and perhaps after argument next month, or I'm sorry, April 18, I believe, in Groff v. DeJoy, this is a huge one, Tony. Title VII of the Civil Rights Act, which applies to both private employers and government employers, does not permit the government, an employer to discriminate on the basis of religion. That employers have to reasonably accommodate the religious beliefs of employees. In the 1970s, the Supreme Court, in a decision called Hardison, it interpreted those words to mean so little that almost any employer could claim that this would be an undue hardship on them. The Supreme Court is going to take a look in April at restoring some real teeth to Title VII, and that's something we should talk about when that argument comes.
And we will, but not today. We're out of time. So we'll talk about that when that case comes up in April. Ken, always great to see you. Thanks for joining us.
Great to see you. Thanks, Tony. God bless.